Mr. Young?
Afternoon, how are you?
I'm fine. How are you?
I'm good, thanks.
All right. We sound okay?
Yeah, it sounds good.
All right. We'll see you shortly. Thank you.
You're welcome.
Michelle, I'm having some bandwidth problems this evening, so I may not have my camera on. But I'll still be here. Just letting everybody know. Michelle, did you hear my announcement? Michelle, did you hear my announcement? Can you hear me? Paul, can you hear me?
Yeah, it seems like she can't hear you.
I can hear you also.
Okay, thank you, Commissioner Wright. Commissioner Wright, while I have you, seize the moment. I know what you have Wednesday, the BZA Wednesday. The case that we hadn't heard, would you mind taking that one since you're gonna be there most of the day anyway?
That's fine. I haven't really, to be perfectly honest, looked carefully at the agenda. I know you had a couple of cases.
Right.
But if there's one that I can take off your plate, I'm glad to do that.
Yeah, we haven't heard the merits or anything. I'm only gonna do decision stuff. They had me down. They continue to hear a hearing case, but we hadn't heard nothing. So since you're there the whole day, I would be more than happy to give you that one.
I'm fine with that. Do you want me to let Kara know, or are you gonna let her know?
Okay, yeah, I'll do it too. But if you, let her know that you're gonna. Yeah, I'll text. I'll text her.
Okay, that sounds
let her know.
great. Thank you.
Thank you. Okay, so we're gonna get started, but I don't think Ms. Shelling can hear me. So let's get her straight first. Stand up, Rod. Let's see. District. No, don't stand up. Let me see your shirt. District of Columbia. Oh, okay. I haven't seen one like that.
Not
This
here.
happens to be the burgundy and gold colors, but
Wait,
keep hope alive.
Yeah. Sharon, can you hear us?
try it now. Can you hear me now? Or can I hear you guys rather?
I can hear you, but can you hear us? I can hear you.
Now I can.
You can hear
Yeah,
me?
sorry about that. Sorry about that, guys.
So you can hear me? Hear me?
Now, yes. Sorry, they finally got me a new laptop and everything, nothing was set up on it. So I was scrambling at the last minute.
So you
We're
can
good
hear.
now.
So you can hear.
Yes.
Okay. All right.
Everything is set up now. I've got everything set up. I was scrambling with 3 minutes.
Okay. All right. Mr. Young, could you start a recording, please? Good afternoon, ladies and gentlemen. We are convening and broadcasting this public hearing by video conferencing. My name is Anthony Hood. Joining this evening are Vice Chair Miller and Commissioner Wright. We're also joined by the Office of Staff, Ms. Sharon Shelling, as well as Mr. Paul Young, who will be handling all of our virtual operations, and our Office of Zoning Legal Division, Ms. Hillary Lovick and Mr. Brian Lampert. We will ask all others to introduce themselves at the appropriate time. Copies of today's virtual public hearing notice are available on the Office of Zoning's website. Please be advised that this proceeding is being recorded by a court reporter and is also webcast live via WebEx and YouTube Live. The video will be available on the Office of Zoning's website after the hearing. Accordingly, all those listening on WebEx or by phone will be muted during the hearing, and only those who have signed up to participate or testify will be unmuted at the appropriate time. Please state your name before providing your oral testimony on your presentation. All presentations should be limited to a summary of your most important points. When you are finished speaking, please mute your audio so that your microphone is no longer picking up sound or background noise. If you experience difficulty accessing WebEx or with your telephone call-in, then please call 202-727-0789 to receive WebEx login or call-in instructions, or if you need assistance to sign up to testify. All persons planning to testify either in favor, opposition, or undeclared must sign up in advance and will be called by name. If you wish to file written testimony or additional supporting documents, I'm reading this twice, so I need to revamp this. Then please request that the submission be entered into the record. Oh, okay, no, it's not twice. If you wish to file written testimony or additional supporting documents during the hearing, then please request that the submission be entered into the record and be prepared to describe at the time of your testimony. The subject of this evening's hearing is Zoning Commission case number 25-11, subtitles D&E Rear-Addition Standards. Again, today's date is October 27, 2025. The hearing will be conducted in accordance with provisions of 11Z DCMR Chapter 5 as follows. Preliminary matters, presentation by the petitioner, which is the Office of Planning in this case, report of other government agencies citywide, report of the ANC, I believe it's citywide. I'll stand to be corrected if it's not. Testimony of organizations and individuals, organizations 5 minutes, individuals 3 minutes, respectively. And we'll hear in the order from those who are in support, opposition, or undeclared. While the commission reserves the right to change the time limits for presentations, if necessary, it intends to adhere to the time limits as strictly as possible and notes that no time shall be ceded. At this time, the commission will consider any preliminary matters. Does the staff, let me say, I have a preliminary matter. I'm having some bandwidth problems, so I may have to turn off my camera at times. So just bear with me. And if I have it off, I am listening, and I'll just leave it at that. At this time, the commission will consider any preliminary matters. Does the staff have any preliminary matters?
All right, I can mute and unmute now. It's been quite an afternoon. So preliminarily, there's really not much to say other than, as you said, this is brought by the Office of Planning. There are some ANC reports in the record. So you have those before you, and lots of letters in support, letters in opposition. So everything is before the commission. I don't have really anything preliminarily to put before you that you need to rule on. If I've missed something, I'm sure that Mr. Lampert will pop in and let us know. But I believe it is ready for the Office of Planning to give you their report.
Okay, thank you. Let's bring up the Office of Planning. Either Ms. Steingasser, Mr. Lawson, or whomever is going to present. I believe it's maybe Ms. Steingasser.
It's going to be me this evening, Chairman Hood.
Is this your last time presenting to us, Ms. Steingasser?
Yes, sir, I think so.
Okay, all right, go right ahead.
Okay. Mr. Young, could you bring up my PowerPoint, please? Okay. Thank you, Chairman Hood, Commissioners. I'm Jennifer Steingasser with the DC Office of Planning. This is a presentation on case 2511, and it has to do with rear additions to attached and semi-detached dwellings. Next slide. So this case basically comes from a long line of amendments and policy changes over the last 10 years, starting with the original 1958 regulations and updates through case 14-11, where we looked at the conversion of row houses to apartments. It was followed by changes to the zoning regulations in 2016. 2019, the mayor's order to reduce barriers to housing. The 2021 comprehensive plan and community facilities element, and then this particular proposal this evening. Next slide. So the proposal is set down and advertised, proposed to increase rear additions on the back of row houses and semi-detached dwellings from 10 feet, which is currently allowed as a matter of right, to 16 feet as a new matter of right. Anything beyond 16 feet would be a special exception. There are also clarifications to the regulations regarding where to measure the additions from, and then the heights and the different number of floors. And it's important to recognize that the additions would continue to be subject to rear yard, lot occupancy, building height, and other development standards. So a special exception to allow for a longer addition would not bypass these other regulations. Next slide, please. This just lays out a graphic that shows the additions. The brown is the existing environment. The gray is the row house, and that would be proposing this. The blue is the proposed matter of right addition. And then the orange represents an addition in excess of 16 feet that would be required by special exception. Then there's a line that still shows the obligatory 20-foot minimum rear yard. Next slide, please. We also did a series of community engagement and outreach through this process. We held 4 virtual open house meetings and invited all the ANCs. We had 2 in June, one around noon and one in the evening. We had 2 in October, also one around noon and one in the evening. We set up a dedicated email address and a website that contained the reports and also the video recordings of the open houses. And what we heard at these virtual meetings was concern about the upper stories, particularly the effects on sunlight and privacy on the adjoining properties. And we had a good conversation with several of the ANC commissioners about that particular issue, and we ended up proposing an alternate proposal text that you will see next. Next slide, please. So the alternate proposal was to continue with the 16-foot ground floor addition, but limit the upper 2 stories to only 12 feet. So it would only be a two-foot increase as opposed to a 6-foot increase. We felt that the 2-foot increase was actually still somewhat warranted for the upper 2 stories, because by the time you measure out 10 feet, you come in 6 inches for insulation and framing, you end up with a room that's basically 9.5 feet at best. It's not particularly a comfortable size room. Most rooms we thought would be more comfortable in the 11-foot range. So we proposed the 12 feet, it's only 2 more feet than what is currently allowed by special exception. I'm sorry, currently allowed as a matter of right. Then anything in excess of that, excess of 16 feet on the ground floor or 12 feet on the 2nd or 3rd floor would still be required by special exception. And again, emphasizing that the rear yard, lot occupancy, and building height and development standards would still apply. Next slide, please. So this is a graphic that kind of illustrates the new alternate language. The two blue buildings, the one on the top represents the current existing provision of 10 feet as a matter of right. You see its relationship to the gray building immediately below it. The darker blue building below that shows the addition of the 16 feet ground floor as represented by the extension of the orange there. And then there's a 12-foot, the blue extension is just the 12 feet. So we had kind of a challenge on how to represent and present this material, because the 2-foot difference between the 2 blue buildings was very minute and very difficult to project. But we felt the real importance was the relationship to the gray existing neighbors, which you can see is very minimal. We also tried to do some shadow studies, but trying to do a shadow study for 2 feet was almost impossible. We really couldn't get a discernible image, so we didn't provide any of those. Next slide, please. So the main objective of this particular case was to address comp plan language about universal design, aging in place, barriers to housing, and minimizing regulatory obstacles, allowing people to invest in their home and stay in their home. And that's for all, not just the aging in place, but also for families to be able to put on a reasonable size addition. We also wanted to address concerns raised by the Zoning Commission about the potential impacts of disproportionately large rear addition. We've seen some examples of those in the earlier cases that were, 30, 40 feet long, and that were really, really uncomfortable for the neighbors. We wanted to clarify the measuring point and actually include development special exception review standards. We felt those were important. We heard a lot from during the BZA cases that those standards could be confusing when there's all this referral back to different sections. We talked with OZLD, and we worked on including those standards into this section of the code. And the idea was to reduce some of the BZA load. And a lot of people have dismissed the importance of reducing that BZA load. But as you know, you sit through these cases can get long, they take a significant amount of lead time just to get on an agenda. It can cost, and those delays can be costly, both in terms of paying professionals to attend those meetings. Architects are often there. Sometimes there may be land use lawyers there as well. And it gets really, really onerous to homeowners. It's not just, there's a lot of fear of developers and flippers, but what we're seeing now is almost exclusively homes that are being built. They're not being built with a, disproportionate pop-up. So we felt that was a legitimate case. We looked at the last 10 years of BZA cases, and we found that the 16 feet really was kind of a threshold point. We looked at it in terms of looking at the universal design standards, which we did a lot of research through various building codes. And as you can see on this image here in the lower corner, there were dimensions that were recommended for different sized bedrooms based on the size of the bed, and typical furniture having mobility circulation requirements for wheelchairs. So adding those together, we came up with the 16 by, this here has 16 by 15. We went with the 16 foot to allow for that mobility around a queen size bed. Next slide, please. Excuse me. We also looked at language in the comp plan directly that talked to policies such as the incentives for accessible units, housing choice for older adults, housing for persons with disability, and removing regulatory obstacles. And they actually refer to making zoning changes to allow for ease of these types of construction. The community service and facilities element also included some language about coordination to better serve older adults and residents with disabilities. Now that we recognize that all of these additions are not necessarily for ADA compliance or for universal design bedrooms, but we felt that at least this removes a burden for those that would want to do that. And putting it on the ground floor, that did make the most sense in terms of the most probability of where a universal ADA compliant room would be. Next slide, please. So then we also looked at the racial equity comprehensive plan analysis. Obviously, this was really more of a neutral effect. There's no displacement, whether direct or indirect. The impact on housing is not likely to have an overall market impact. I'm sorry. The change would not affect additions to the rear of properties necessarily in terms of public space or urban design. And then the access to opportunity is really a kind of a neutral. This text amendment would have very little impact on that. So we found that there was very neutral. Obviously, all races, all ethnic groups are aging. So it was fairly even across the board. Next slide. These are some examples that we did, just showing there's a lot of concern over where does that 16 feet get measured from. And we wanted to be clear, it's measured from the rear wall of the adjoining property. And it's the one that is the furthest away. So you couldn't do a 16 foot and then come back 2 years later and measure 16 feet from the other side of the neighbor who may be closer. It would be to grab that which would have the biggest impact. And in this case, what we're looking at is the buildings are already built more than 16 feet. So any addition would be a special exception. Next slide, please. This one shows one where they're actually into the rear yard, and it would be special exception for the rear yard extension and for the addition. But because it also would violate lot occupancy, this would also trigger a variance. So there's a lot of ways that these rear additions are being controlled. Next slide. So in summary, OP is recommending that the commission approve the alternate proposal of the ground floor at 16 feet and the second and third floor at 12 feet. And again, that's 6 feet more than existing and 2 feet more than existing. It's not a 16 on top of the 10. It's you know, and 6 feet, you know, when you think about the average height of a man, it's not that great a distance. We also request that the commission authorize OP to work with OZLD and DOB to prepare the draft language for the notice of proposed rulemaking, which we did include a sample in the report, but we have not detailed that language until we get some further feedback from the commission. Thank you, and I'm available for any questions.
Thank you very much, Ms. Steingasser. We appreciate the diagrams and the presentation given to us. Let's go and see if we have any questions or comments or additions. Commissioner Wright?
So I've looked at a few of the web pages, in fact, found the image that you used on one of the web pages that is suggesting the 16.25 by 15.5 from the Home Modification Occupational Therapy Alliance. However, the DC Office of Accessibility, sure I have the wrong name, says that a 10 by 12 room is typically sufficient. How do you sort of justify that difference?
I don't know why they would. I mean, those are the standards we found when we looked online at several locations, at several sites had larger than, I mean, that may be the size for a twin bed. You know, we tried to look at something that is more common, you know, queen or king size beds are what most people have. Maybe the smaller space would be a twin bed or maybe a double.
Okay, thank you. I think that was my only question.
Okay, thank you. Vice Chair Miller?
Thank you, Mr. Chairman. And thank you, Jennifer Steingasser and the Office of Planning for bringing this case forward. We've all sat on many BZA cases since the adoption of the 10-foot rule. In general, I think it's been a good rule for us to be able to evaluate adverse impacts if there are any, when there's an addition proposed beyond the 10 feet. But as you point out, in the 16 cases where was it 16 cases where there's 16 feet?
It's 16 feet. Yeah, we looked at many more cases.
Yeah, but it's 16 cases that were approved where it was 16 feet back instead of 10 feet. Is that correct?
Let me check the exact numbers
And
here.
Okay. Well, while you're checking, my experience is what you described, which is that we approved these when on the cases that BZA case I sat in on, when the ANC was recommending approval or had no objection, when the Office of Planning was recommending approval, and when the adjacent neighbors either were approving or had no objection. So it has been the case that that those were the cases where we could evaluate adverse impacts if the adjacent neighbors and the ANC are saying that there aren't any. That was, so I mean, if we can take some of them off the table of the BZA's plate and reduce the burden on homeowners seeking to have a ground floor deck that goes 16 feet instead of 10, I think it's a as well as other additions, including the universal design type of bedroom that you've described. I think that would be a step in the right direction. Just following up on Commissioner Wright's question, maybe we might need more information about what are the standards for universal design in the District of Columbia. I assume that they might be in the building code. I'm not sure where you found them on for your OP report, or where Commissioner Wright found them for her reference to a DC standard. But I would think they would be in the building code that applies.
Well, we did work with DOB in the zoning administrator's office in the preparation of these regulations. But I can have someone check again. And it could be that the 10 by 12 is a bed that's up against the wall. So you're only getting, an individual's getting in from one side. You know,
I can just read what I'm seeing on the internet right now. It says, while the DC Housing Code sets the legal minimum, it's possible for a room to meet the 70 square foot minimum, but still be inaccessible. To be truly handicapped accessible, a bedroom must be large enough to accommodate both the furniture and the required clear floor space for a wheelchair. A 10 by 12 foot room, 120 square feet, is a common size that can comfortably meet these maneuverability standards. So,
okay, there you go.
So yeah, maybe we can get just some further clarification if it's applying to that's the housing code. I think that you just reference, maybe a building code reference. Then if you can just clarify that, maybe in a.
Well, I mean, the standards we looked at included a 3-foot aisle for circulation by a wheelchair, plus 2 feet for a piece of furniture, and then the width of a queen size bed. And those numbers, that's how it added up. So if they're using a 10 foot.
I can see how that's much more comfortable, whether you're using a wheelchair or whether you just have mobility issues in general and need more room to walk around. And that's just a more livable space, obviously, especially if it's someone who's aging in place. And I appreciate all the community engagement that the Office of Planning did in this case, that you went back after the set down and then got additional input regarding the second and third floors, and you made it an adjustment and proposed an alternate proposal. Instead of the 16 feet, you reduced it to 12 as a matter of right. So I appreciate that responsiveness. The ANC 6C in their filing that we just got over the weekend, I think, exhibit number 17, they make a statement that your OPs on page 2 of their letter, in which they oppose the change, but they say that the alternate, and they appreciated the alternate change, but they said the alternate proposal would expressly affect only R zones as presented. The new text does not clearly make any change with respect to RF zones. I'm reading from their letter.
Right.
I thought I saw RF reference in your text, but
Well, ultimately, we were in a bit of a hurry, and so we put together just an illustrative image, draft, but it would obviously be expanded to be the R and the RF zones, as well as it would require some renumbering. But yes, the text is meant to be both R and RF zones.
And your report, in my mind, clearly implied that, but or if the text did not, or illustrations did not. So I'm not sure I have any questions at this time. I appreciate your swan song presentation to the Zoning Commission and all your work that you've done on this case.
Sure, thank you.
I do appreciate it, Ms. Nygaster, with the report and everything, but I want to walk down the lane. It takes me a little long to get to where we are. I believe, didn't we ask to revisit this and look at this 10-foot rule?
Yes, yes.
And I want to respond with Rob. We all have different experiences. My experience has been that the 10-foot rule has been there, but we basically have did exactly what we're talking about here today. The ANC may have approved it, Office of Planning said do it, and both neighbors on the side were against it, and we still approved it. I think some of my records show that I had voted against it, but I'm slow to adapt, and I'm learning to get there because I thought of the adverse impacts that it caused, and I do like the lower floor versus second floor. And I know there's a lot of opposition. I'm just trying to remember, Ms. Langasser. And I'm not saying that this is a non-starter for me. I'm trying to remember, how did we get to was the 10-foot rule proposed by a community, or did the Office of Planning propose that? I'm trying to remember how we got there.
I don't remember who exactly proposed it. It came out of case 1411. And I remember it was Deputy Mayor Otero, Bibi Otero. I think in her testimony, she identified some property on her block where the rear addition was something like 40 some odd feet long. I mean, it was one of these really large lots, very long, and it was just this huge, and we didn't do any study. It came from that hearing, and I don't remember who recommended the 10 feet, but it was an extension of that hearing on the conversions of row houses into apartments.
I want to say, Mr. Gambrell, I can see a letter from him. I want to say it was there. I just can't remember. I'm just trying to figure out how we got here. I just know what our track record has been. It's taken me a while to adapt to even approve them on the BZA. And I just know, and I appreciate the special exception after the 16 feet. At least that's the way I understand it. I think that's very important, because the reason why I think that's important is because there have been some structures that were very, I'm not going to say, I don't want to use the word disrespectful, but I am disrespectful to some of the surrounding neighbors. So I'm not going to say distasteful, but disrespectful. And we want to make sure we have some type of input, especially those who are being impacted. So I appreciate what we come back with. I think Office Planning has done its due diligence, but I'm also want to hear from the public, and I know others will be able to tell me how we did with that 10-foot rule, because I just don't remember. I remember being there, and I remember how I got here to a point, but I just want to make sure I understand the track record as we continue to progress. All right, I don't have any other questions, Ms. Steingart, so thank you. Colleagues, any other follow-up questions, comments? Okay. All right, let me go to give me 1 second. Okay, let's go to Michelle. Do we have any other government agencies?
No, sir.
Okay, I know we have a few ANCs. Can we call all the ANCs up first?
Yes, we can. Let me get to the witness list and see if I can sort them out. They each get, do you want the ones in support first? Because they get called differently. We got support and opposition.
Let's do support, opposition, and then undeclared.
Okay, sure. Let me pull that list up. Let's see what we got here. It's like my computer wants to download everything. Ella, are you on still? Could you go ahead and call up the ANCs, pull up the list? Because my laptop is trying to download everything from ISIS now.
If she can, I can see the.
Can you see the witness
Yeah, I can
list?
see them.
I can call them up.
You can, yes.
Okay.
If you could call the ANCs, those in support first.
Okay.
Thank you.
Mm-hmm. I don't see any ANCs in support that I've signed up. I just see ANC 6C in opposition and ANC 2E in opposition.
Okay, could you get those up? And then if there are any undeclared
Okay.
after that. Could you just call those names, please?
Oh, yes, sorry. Mark Eckenweiler and Gwendolyn Lowe's. They are here. I'm looking now.
I only have Mark on. I don't see Miss Lose.
Okay, I spoke with her earlier and she did want to testify, so we'll see if she shows up.
We'll see if we get her, but let's begin with Mr. Eckenweiler. Good afternoon, Mr. Eckenweiler. You may begin.
Good afternoon, Chairman Hood and members of the commission. Mark Eckenweiler, Vice Chair, ANC 6C, appearing on behalf of the commission. As noted in our filed comments, that's Exhibit 17, we voted 7-0 to oppose this text amendment. That vote was taken in September, so it was prior to the hearing report that OP filed within the last 10 days. But we remain in ardent opposition to everything that is proposed here. So let me walk you through. I'm not going to repeat everything that's in our written submission. We think that the same conditions that necessitated the adoption of the 10-foot popback rule in ZC case 14-11B still exist today. And we think that the process has worked really well. We, as an ANC, our territory is dominated by row house neighborhoods. We are not entirely, but I suspect about 2/3 of our land is RF. We are the north side of Capitol Hill over to about 7th Street or so. And so this is meat and potato stuff for us. And I think what we have seen time and again is that the 10-foot allowance past the neighbor's rear wall is sufficient to allow people to make meaningful additions to their houses. And when they go beyond that, the public process is crucial for us to understand, both hearing from neighbors, both looking at the individual configurations, because you know how odd things can be in row house neighborhoods. You know, you've got funny shaped lots, you've got, you know, trees, you've got, you know, lots that are perpendicular to each other, all kinds of different configurations. And the ability to examine the individual facts, look at sunshade studies, for us has been key. And we think that the existing rule strikes the appropriate balance, and we think that process has worked really, really well. And this text amendment would radically upset that balance that's been struck. So let me focus here. There are two separate things going on here. One is the obvious change going from 10 feet to 16 feet. Okay, that's the thing that's on the surface that we can all see. If you take nothing else away from my testimony, and I hope you take more than just this, but the key point here, and this is discussed in paragraph 2 on page 2 of our submission, remember how the BZA assesses the adverse impacts for purposes of section 5201. It looks not at what's the existing condition versus the proposed condition. It looks at what could the applicant build as a matter of right, and then what would be the incremental adverse impacts, if any, from the proposed condition. And so when you move that baseline from 10 feet to 16 feet past the neighbor's rear wall, what that means is, you know, that applicant might as well ask for 18 or 20 or 22 feet, because the incremental adverse impacts are going to be very small compared to the hit that happens between 10 and 16 feet. And I really would implore you to think really, really carefully about where this leads. And I understand the point that, you know, OP is making about, well, you know, we've got, you know, a lot of occupancy and rear yard and so on. First of all, the rear yard standard is the same standard. It's the same criteria as for going past 10 feet. So, if somebody's got a 115 foot, 120 foot deep lot, and we have plenty of those on Capitol Hill, then why wouldn't they just go back 20 feet? So I think a lot of nuance is being lost here. I do also want to respond briefly. This argument that somehow this is conducive to efficiency, I think that's an insult to the commission's intelligence. OP said over the last 3 years, there were 16 such cases. That boils down to about 5 cases a year. That is static. That is a negligible fraction of the BZA caseload, and their study doesn't say if any other areas of relief were required in those cases. Plus, if somebody's going back 16 feet, they probably will be needing more relief. So the truth is, you're not going to get a reduction of 5 cases a year out of this even. So that is not a serious argument in favor of this. Mr. Chairman, I see my 5 minutes is about up. May I just take another minute or two to thank you? Appreciate that. So as I said, we took our vote when just on the basis of the pre-hearing notice, the original proposed text for this hearing. And as has been discussed, OP has proposed this alternative where the upper stories can only go back 10 feet past the neighbor's rear wall. We don't think that cuts the mustard. First of all, let's think again about how there are going to be individual scenarios where there can still be adverse impacts from even a 1-story addition. So think about where there's a significant grade difference between the applicant and the adjacent neighbor. But also that's about air and light. When you go back 16 feet, and the upper stories are only going back 12 feet, maybe less, then you're going to have they're going to be roof decks on that rear addition. And that implicates the privacy, the overlook into the neighbor's rear yard from the top of that 16 foot past the rear wall addition. So all of those factors that go into analyzing section 5201, I think they are still present. And so we still emphatically oppose even the revised proposal. And so I do want to say one other point, and then I'll conclude. I have a lot of thoughts about why OP's argument that, well, 16 feet is a sweet spot because of, this particular thing, that is a fiction. If you want to ask me about why I think that's a fiction during Q&A, I would be happy to elaborate, but I've already, taken advantage of you by going well over 5 minutes now. So let me just say, I offer that as, some further testimony if you want to hear it. And in conclusion, this text amendment is a solution in search of a non-existent problem, and we emphatically urge the Zoning Commission to reject it. Thank you. I'd be very happy to answer any questions.
Okay, thank you. Let's see if we have any questions. Oh, wait a minute. Hold on. Did we bring anybody else up? Oh, that was it. The other person was Commissioner Lowe's was not here. Lowe's was not here. Okay. All right. Commissioner Wright, you have any questions of Commissioner Eckenwald?
Well, I can't resist. Why is it a fiction?
It's a fiction because it sort of assumes, is this sort of like when you took high school physics and you were told to assume, weightless ropes and, frictionless pulleys. It assumes that 16 feet, it's predicated on the idea that, the applicant's house, and let's just imagine for simplicity's sake, there's only one neighbor, that they have rear facades that are perfectly well aligned. And while that was true for a lot of the houses on Capitol Hill and other RF zones, and still remains true in many places, all kinds of changes have been made to these houses. So let me spell out, make this concrete. Let's say I'm the applicant and I only have one neighboring house. My house is 4 feet shorter than their house right now. If I need to get 16 feet, and I'm not accepting, this premise that you need 16 feet to have an accessible room, but just for argument's sake, let's say I need 16 feet for that reason. Right now, I only need to go back 12 feet past their rear wall because I've got 4 feet just to get in line with them. Conversely, imagine where I am already 4 feet past the neighbor's rear wall. Under this text amendment, I'm going to get another 12 feet. So that's not 16 feet, that's only another 12 feet. And you can think about all the different possible combinations and permutations, especially when you start adding in, the possibility of there being two neighbors. And suddenly you can see that this sort of, this, in a vacuum notion that, changing this rule to a 16-foot rule that it's going to solve people's problems, that will be true in a small number of cases. But in the vast majority of cases, either they're going to need more than this 16 feet, or they won't need all this 16 feet. So it's just purely notional that this can somehow be justified by this argument that you need, a 16-foot room for accessibility. So I hope that puts it in a nutshell, but I'm happy to elaborate if that wasn't clear.
My other question is just to verify that, I know you're representing Capitol Hill, that what's the width of most lots on Capitol Hill? I mean, my understanding, I'll tell you, is it's 15 to 20 feet generally in terms of widths. Is that pretty accurate?
I would say 15 feet is unusually narrow. 16 feet is not uncommon. My house and just about all the houses, on my block are 18 feet wide, and that's pretty standard. There are ones that are wider, but I think 17 or 18 feet is probably, the median.
And so if you added even 10 feet to an 18-foot wide row house, you have a new room that is 180 square feet in size. Would that be accurate?
That sounds right to me.
And again, I think that there's lots of ways to organize furniture in a room, but 180 square foot bedroom is a pretty large room. I mean, that's my statement. That's not a question, actually. A bedroom that's 12 by 12 is only 144 square feet. And that a 12 by 12 room is quite large. So anyway, I would just sort of say that I think you've made a number of good points. So thank you.
Thank you.
Okay, Vice Chair Miller.
Thank you, Mr. Chairman, and thank you, Commissioner Eckenweiler, for your always very thoughtful testimony and for the ANC's letter in opposition at Exhibit 17. I assume you don't know this off the top of your head and didn't bring this with you, but do you know how many cases since the adoption of the 10-foot rule your ANC has reviewed, and what percentage just on the 10-foot rule, because as you rightly point out, lot occupancy and rear other relief might have been part of it, but on just the 10-foot rule, do you know how many you're of the or percentage of the ones that of the 10-foot rule extensions that you approved, you opposed or approved or recommended approval?
So just so make sure I understand the question, are you asking me, Commissioner, how many, I think we've had since 1411B came into effect, or kind of what the approval, disapproval, no position mix was, or both?
It was both.
Okay.
So that's, I mean, and I'm sure there are a lot of them, but so.
Yeah, I'm reluctant. I don't know the actual answer. I don't have hard numbers for you on either of those. But it's just an extraordinarily common, I think for us, it's probably second only to special exceptions to go up to 70% lot occupancy. I mean, those, that's really meat and potatoes for us. In terms of how many we support or oppose, I think we tend to support, but up to a point. And I think part of what's going on here is that because the 10-foot rule sets that boundary, that baseline for what can be built as a matter of right, and as I emphasized, in my oral testimony and on page 2 of our letter, because the BZA standard, which frankly we fought against for a number of years, we really thought that the test ought to be existing condition versus proposed condition, but the board keeps shooting us down on that, and so we ceased to fight that fight. But I think that has had the salutary effect of constraining these additional requests for additional depth to reasonable amounts. And that, I think, is why we have tended generally, sometimes, because the neighbors didn't care, sometimes over violent neighbor opposition that we thought was not well founded. We, I would say, more often than not, support these kinds of applications. But I can tell you, we absolutely have opposed a number of these. I'm thinking of one in particular where the board approved one over our objection, and even though we pointed out that the sun shade studies were manifestly fraudulent, they showed things that literally could not exist. But so you win some, you lose some. But to me, it's less about do we support most of them or not. It's about how do we get there, and the way that we get there, knowing to support them or oppose. And like I say, we've done both, is through this process of analysis. We have some very competent, architects who tend to bring these before us over and over and over again. They know how to do the proper sunshade studies, and it is highly informative. And if you suddenly take that away and just make this matter of right, then, as I say, one, all of that nuance and all of that discernment that goes into that decision out to 60 feet, that just goes away. And like I said, it just raises the baseline for what the how significant the effects are or aren't if you go even further past 16 feet. So I apologize, that's a bit long-winded, but to put it in a nutshell, we think the process is working really well. It is not unduly onerous on applicants. We tend not to beat people up, and I think they generally get approved, but I think the process is highly beneficial for everyone involved. Even if the objecting neighbor doesn't get their own way, I think it is a very, very useful exercise. And not just because we should go through the exercise, because it really does inform us, and I think it informs the decision makers at BZA about what should not or should be approved.
Okay, well, thank you. I appreciate that response and your being here today. That's it, Mr. Chairman.
Okay, thank you. Thank you also, Mr. Ekenrowley. You're always very thorough in your analysis to us and very helpful. And I too would agree. The fiction scenario, I would have prompted it as well, but I thank Commissioner Wright for doing that. I believe that a number of us, including myself, wanted us to look at the 10-foot rule. Because I didn't think, my thing is, if we're going to always deviate from it, I always say, well, I have it. But we're always going to go back. So I see what the Office of Planning is doing. But let me ask you this. So basically what I'm getting from you, and I'm going to try to sum up what you've said very quickly in a nutshell. You basically are saying, there's nothing wrong with what we have here. Let's keep just working with that. Is that a fair assessment?
Yes, and I would just add one, little codicil on that, which I stated in my testimony, which is the same sorts of pressures, the same sorts of potential ills that existed in 2017 when this rule came into effect exist today. And so it's not just that it's a good process, but the potential adverse impacts, the threats to air, light, and privacy of neighbors, those still exist. And I think this is an important safeguard. But yes, I would agree with the proposition you just stated.
Okay, all right. That's all I need. All right, hold tight. Commissioner Ekenrowley, I think we have Commissioner Lowe's here. So we're going to hear from Commissioner Lowe's, and we may have a continued exchange. But let's see how it goes. Commissioner Lowe's, you may begin.
Hi there. Good afternoon. My apologies for joining late, and I hope you can see me. I'm traveling, so If not, please let me know and that you can hear me. Our commission did review this, and I'm the chair of ANC2E. We are a federal historic district, and we thought about this, discussed it for multiple months, put it on our application and our agendas to get feedback from our constituents. And we are opposed to this order or the proposal. We are confident that the existing requirements to obtain a special exception for such extensions is an appropriate balance of relevant interest. The 10 feet is appropriate. It does work today. And we are concerned that the 16 feet would impact a change that could have on adjoining neighbors access to light and privacy. And we request that the zoning commission reject this proposal. What we have is adequate today and it works. And we propose that you reject this. Thank you.
Okay. All right. Thank you, Commissioner Lowe's. Let's see if we have any questions for you. Commissioner Wright?
No questions. Thank you.
Okay. And Vice Chair Miller?
Thank you, Mr. Chairman, and thank you, Chair Lowe's, for your testimony and being here today while you're traveling. We can see you very clearly, hear you very clearly, and we appreciate ANC2E's deliberations and their submission to us at Exhibit 8, their opposition statement. So thank you very much.
So, Chair Lowe's, the theme that I'm hearing from you and from Commissioner Eckerweiler is what we have in place now works. Leave it alone. That's the theme I'm hearing from you two so far.
Correct. And I think the numbers in the applications that you put out in the proposal or that Office of Planning did demonstrates that as well, just my personal comments. And then additionally, I would ask you to think about if you do, some of the historic lots are much smaller. If this is driven by new lots, maybe there's some carve outs that you can do, but I think you're hearing from Capitol Hill and ANC2E, which is Georgetown, the Georgetown part, is that what we have today does work. And we have seen some people that use the 10 feet and if anyone that goes beyond, we spend time looking at that exception. It works today. It promotes good dialogue around air and light and also maintaining the historic structures.
Okay, thank you, Commissioner Lowe's. Any other follow-up questions or comments for either Commissioner or Chair Lowe's? Okay. All right, I want to thank both commissioners and Chair Lowe's and Commissioner Eckerweiler. We appreciate you providing testimony. Okay, Michelle, let's go to those persons who are, do we have any persons who are here who are in support?
We have one.
Okay, let's bring that.
Sure. That's Will Tess or Tees. I'm not sure how to pronounce it. Teass, Mr. Young.
Okay, Mr. Tees up.
It's Mr. Tays, actually.
Tays, okay. I'm sorry, Michelle messed that up. Okay,
No.
Mr. Tays, you may.
All right. Good afternoon, Chairman Hood and members of the Commission. I'm testifying today on behalf of the Washington chapter of the American Institute of Architects. In addition to serving as the President Emeritus of the Board of Directors, I also volunteer as a member of the chapter's Advocacy Committee and Small Firm Exchange. I had attempted to file a letter, but I think my filing was deemed late. And so this is the first time that our Advocacy Committee is playing a more active role in Zoning Commission hearings. And so I apologize for that and hopefully have an opportunity to submit the full letter into the record if and when appropriate. So I ask the Commissioner's indulgence in accepting my verbal and written testimony today. The point that I wanted to make today is that both our Advocacy and Small Firm Exchange have reviewed the proposed changes, the original changes that would extend the 10 foot to 16 feet. And we strongly support the original language that gives us architects of the DC area more design flexibility. This is something that we're hearing from our clients. Many times it's a homeowner that they need that additional space to create habitable rooms. In our opinion, this constitutes a modest increase in the rear addition depth, and what it does is greatly improve the functionality and livability while maintaining the overall neighborhood character. I think one of the things that we heard and saw in some of the diagrams is, or the lack thereof rather, is the discussion about light wells. And so the diagrams that were provided by the Office of Planning presume that this rear addition would extend the full width of the property. And I would argue that a lot of times the 10-foot addition has encouraged us as designers to fully build from property line to property line, oftentimes eliminating the light well. And light wells are an incredibly important feature of row house construction. They allow natural light and ventilation, often shared with neighbors on the opposite side, to penetrate deep into these what are sometimes deep spaces. And I think what extending the 10-foot rule to 16 feet does is it brings back that degree of flexibility. And I think that that's something that should be taken into consideration by the Zoning Commission. So as I said, we as members of our advocacy and small firm exchange are greatly in support of the original proposal. We've reviewed the alternate proposal where the ground floor would extend back 16 feet. The upper levels would be limited to 12 feet. And while we understand where that came from, I think that it introduces some complexities to the building form. I think it was alluded to in one of the previous ANC commissioners' testimony that you might end up with a roof deck or multi-level decks that I think actually could create more of a hindrance with regard to privacy. I would also like to say that this is a problem. I think this is a problem if you were to ask any homeowner who we present with, if you wanted to build a room that's 12 feet, 2 feet more, or even 14 feet, that you now have to go through a process that under the best of circumstances adds an additional 4 to 6 months to your project, or in the worst case scenario, adds in excess of a year or a year and a half to your process, depending on how the cards shake out. And so I think it's important to understand that this is truly, in fact, a problem. I thought it was really interesting that both commissioners testified that in general, these cases are approved. In our experience and our members' experience, that's been the case as well. And so I do think that there is a problem. And I think that it's something that exists today. The other piece that I wanted to emphasize is that this doesn't negate the rear yard. This doesn't negate the lot occupancy. This doesn't negate the special exception process. So for those extraordinary cases that were really the genesis for implementing this rule, those fail-safe, those mechanisms are still there for the Office of Zoning and the Board of Zoning Adjustment to review in regards to the extensions to the rear. So in conclusion, I just say on behalf of our committees, we respectfully urge the Commission to adopt the original proposed language stating that a rear building wall, rear building facade can be constructed no more than 16 feet from the closer of the two adjacent structures. And we really appreciate the Office of Planning's thorough study of the issue and preparing that proposal that really addressed not just design, but demographic trends, regulatory considerations, and design implications. So with that, I conclude my testimony. Thank you so much.
Thank you. And Mr. Tays?
Tays, yes.
Tays again? Tays. Okay, so thank you for your testimony. And you can provide that to us, your testimony. Let's see if we have any questions. Commissioner Wright?
Well, a question I have, although you may not have the actual data on this, is how frequently are you seeing significant rear additions being proposed by clients because they want a handicapped accessible bedroom on the ground floor? I mean, I was on an architectural review committee for a community in DC, and the vast majority of additions that we saw were to add larger kitchens and family rooms on the ground floor and perhaps a new master bedroom suite on the upper floor. But I'm just curious, how many generally in your own practice or in discussions you've had with other members of the AIA are you really seeing folks asking for a handicapped accessible room on the main floor?
Well, I think to answer your question, we haven't seen a lot of demand for that. I will say that most of what we see are families who want to stay in the city and often need that additional space, a living room that doubles as a vestibule with several kids and all of the stuff that comes with that. It just isn't enough space. And so we often see, whether it's in a large kitchen or a family room, I would say on the upper stories, it's really not a deluxe master suite as much as it is just an additional bedroom or two for families that have 2, 3, 4 kids. And I think, you know, I live on Capitol Hill. I have 3 children. I was actually impacted by this rule. And I think that, you know, what we're seeing is it's more applicable to homeowners that want to stay in their homes, homeowners that want to support intergenerational living, homeowners who want to be able to stay in the city and really trying to adapt the, you know, historic row house fabric to modern living. So I think that more than answers the question, but I think the demand is for the universal bedroom on the lower level to be is relatively low. I do think that we are having bedrooms that are workable, so it's not just the bed and the clearances that are required, but also the furniture is something that we do hear about quite a bit.
Okay, thank you. I think that was my only question. Thanks.
Thank you, Vice Chair Miller.
Thank you, Mr. Chairman, and thank you, Mr. Tace, for being here today and providing this testimony. And I look forward to reading the written submission that you are going to make, that you tried to make, I guess, in the last, beyond the deadline, whatever it was. So, and I appreciate that the AIA, it's the DC chapter, I assume.
Yes.
Has now, you say it's a more recently, or the advocacy committee has recently decided to get involved in it more, or is it that there's a new advocacy committee that you all formed? And I think it's a good thing. We need to hear as much information to make an informed decision as possible. So, and you bring a professional perspective and practice before the BZA regularly, and you as yourself as a homeowner. So, but is the advocacy committee recently formed, or you just decided to play a more active role with the existing advocacy committee? Just out of curiosity.
Sure. So the advocacy committee has been around for a while. I think that typically it's looked at matters before city council, although this year we're increasing our focus and reviewing opportunities to comment on matters that come before the zoning commission, really representing the you know, we have 2,300 plus members in the area, and getting their perspective and their expertise to look at some of these issues. So we see ourselves as a collaborator and someone as providing resources for the zoning commission to help sort of study these issues. It's actually modeled on behavior that we're seeing other committees take in other cities, where those advocacy groups are providing design assistance, quite frankly, to their comparable counterparts in the Office of Planning and Zoning Commissions.
Thank you for that response. I appreciate your involvement and testimony here today. And that's it, Mr. Chairman. Thank you.
Thank you. Thank you, Mr. Tays. I too have a question for you. This maybe coming from a different angle. Your clients and the AIA, you all believe that this is appropriate, but you just heard from 2 of our commissioners in the city that, to me, the way I took it from them, and I want to see what you would say with this, does that take away the conversation that I believe that's being had? If we do this, does that take away some of the conversation and some of the nuances that are able to develop and the inner engagement that maybe 2 neighbors or budding neighbors are having, or the ANC is having? I'm not, the Office of Planning is going to have this, but I mean, does that take away the conversation with the 10-foot rule and somebody coming in front of the board to be able to have that conversation? Does that take away the engagement?
So I just want to make sure I understood the question. So the question was specifically, does, by adding the special exception framework or the special exception process, take away from the engagement between property owners? Is that?
But no, by adding the addition from 10 to 16, and then the special exception. I know that that's engagement, so I'm not worried about the special exception, but by us making 10 to 16 as a matter of right, does that take away the engagement of helping the development? You know, I really know the answer myself, but I just wanted to see what you say. It actually does. So, you know what? I want to ask you that. That's good.
Oh no, I mean, I would like to answer because I do think
Okay,
I don't think it takes away the engagement, because the reality is once you get to the building permit process, you have to go through a very detailed and regimented neighbor notification process. Oftentimes, if you're going to be building past your property, you're going to have to negotiate an agreement to actually execute that work. And so I think that in our opinion, I don't think it does take away that framework, whether it's 10, 12, or 16 feet. I think when you get into cases where there's a substantial addition, that's a different story. But I do think the reality is when you have neighbors and you're building on a lot line in a city, the Department of Buildings has a mechanism through their neighbor notification process that really address that engagement and discussion.
Okay. All right. I thank you. Oh, somebody's calling. I'm going to turn the phone off. Hold on one second.
Can I ask another question for a moment? I was definitely interested in the comments you made about having a light well, and I agree. I think that is very important. And I understand what you said about if you add additional flexibility to extend farther back, there's more likelihood that you'll get a light well. Do you think that if there is a change that allows for additional extension back on the ground floor, that a light well should be required?
That's an interesting question. I mean, I think there's a practical reality of when you get into the depth of a row house, what you can actually do with those interior spaces, right? A bedroom is required to have a window to the exterior for light and air. And so by having, deeper row houses, it actually, the space in the middle does not get terribly well utilized because of that. And so you end up sometimes with very strange, very long bedrooms, right? But I do think it would be interesting if there was some guidance with regard to, maybe a set of proportions or something that sort of talked about this that would encourage people. Because what we've seen is that, many people want to fill in the light well because they want, they don't want to go and get special exception relief to go 11, 12, 13, 14 feet. But they can fill in that light well, which I think is actually compromises sometimes the light and air of those interior rooms. And so I think considering some mechanism would be interesting to sort of see what I've been here sort of sketching these visual examples in my head of what that could be. And so that's an interesting possibility to add that requirement that if you wanted to do that, you had to provide a light well. So I think it goes back to where, the actual, if you look at the historic development of those row homes, many, including my own, had one, and they have very good reasons to do so. And we still have a requirement, thankfully, to provide light and air to bedrooms. And so that might be an interesting compromise to consider.
Thank you.
Okay. Any other follow-up questions? Thank you, Mr. Taz. I don't have any questions, and we're looking forward to the advocacy from AIA and your group as well. So thank you.
I'll be back. Thank you.
Right. All right, Ms. Shellen, do we have any other support?
No other support, just a couple in opposition, not too many others. That's it, just a few others in opposition.
Okay, let's bring up all those in opposition, and I don't believe we have any undeclared. So let's bring up the opposition.
Sure. Alan Gambrell, Anthony Smith, and that concludes the list, Chairman Hood.
That's it?
Now let me refresh it just to make sure no one came in last minute. That is it. Yes, sir.
Okay. We will start with Mr. Gambrell, and then we'll go to Mr. Smith. Mr. Gambrell, you may begin.
Okay. Yes. Good afternoon. Alan Gambrell, Ward 1. I have enjoyed working with the Office of Planning over the years on various zoning regulation issues, pop-ups, basement cellar, and so having learned on the call that Jennifer Steingasser is moving along, I wish her good luck in her future endeavors. As far as my involvement with this case, I was not involved in development of this regulation, which is clearly a pushback overreach. As far as prepping for this, I had looked at the case record for 14B and was really struck that there was very little in the case in terms of support or opposition. So I kind of wondered, where did this rule come from? And Jennifer Steingasser explained that. And I make that observation when it comes to 2511. There are 12 statements in opposition on the record. That's clearly a massive amount of opposition on this case, and it's in stark contrast to where this rule actually got developed under 1411B. So I think that's very notable. And the other thing I think is notable is I didn't work with anybody else as far as making opposition statements. So I'm really struck by how common the themes are across the statements of opposition. They're very thoughtful and they're very consistent in terms of their rationale. I wanted to quickly summarize my submission along with architect Guillermo Reyera, and it's in Exhibit 11. I'm just going to hit some highlights. I'm going to really scan through this. One, as far as aging in place as an argument, I find that to be highly speculative. In fact, I want to make this observation. Maybe it's a little bit speculative as well, but as far as aging in place, I think people who get older and live in row houses, they cash out. They move, downsize, they move. So I don't find that argument one bit persuasive. Second, as far as the Board of Zoning Adjustment and their workload, I mean, I think it's already been stated, what burden? It sounds to me like they're basically doing their job. I think a greater concern, however, is moving from 10 to 16 feet. Would the Zoning Commission and the Board of Zoning Adjustment basically be moving the goalpost? So would those routine special exceptions for 16 all of a sudden become routinely 20 feet? I think that's a real risk that the goalposts get moved. Third, as far as the negative impact as far as the depth of rear yards, that's not something that's been addressed whatsoever. I'm just going to give one example of a relatively shorter rear yard. It's one of, say, 60 feet of a rear yard. With the current 10-foot pushback, 25% of the rear yard is going to be obstructed. If you move it to 16 feet, it's going to be now 40% of that rear yard is going to be obstructed. That's a huge, huge impact difference. And that's going to be relatively less as the rear yard gets deeper. So I urge you to look on page 3 of Exhibit 11 for a chart there that shows how the percentages vary based upon the rear yard depth. And my fourth and final point, I think, is as far as keeping it at 16 feet on the ground level and going to 2 feet, clearly the Office of Planning has heard some feedback about the negative impact on light and air, but I don't find that to be incredibly persuasive because think about it, where do people use their rear yards? They use them on the ground level. So keeping it at 16 feet to me doesn't seem like a persuasive argument for doing anything respectable in terms of light and air and being respectful of that. I'm just going to stop at that point and thank the commissioners for your time. And I urge you to oppose this amendment. Thank you.
Thank you. Hold tight. We might have some questions for you. Mr. Smith, you may begin. Mr. Smith?
If you're asking, I'm sorry, we're going to hear from the other.
Yeah, we're going to hear from Mr. Smith first, and then we'll.
Oh, I'm sorry. I didn't have any questions for him. So I'm fully in opposition to this proposal as well. And I'm sorry that I am coming in late to any of this because I didn't have time to submit my testimony or anything. But I first heard about this proposal after learning that a developer plans to build a multi-story apartment building next to my home. Looking at the proposed design was my wake-up call that this rule change isn't about accessibility or helping homeowners. It's about opening the door to wider, more speculative development in neighborhoods that are already tightly under pressure. The support of the universal design standards and aging in place to me doesn't feel genuine, to be honest with you. Anyone who walks through the alleys of Petworth or Parkview or Bloomingdale can see that this is not how any of these things are being built. Developers aren't adding wheelchair-friendly units or accessible floor plans. They're adding luxury multi-unit conversions, 2, 3 apartments carved out of a single-family row house. Projects that have nothing to do with accessibility and everything to do with their own profits. If you can you can buy a house for $500,000, stick 3 units in it, and sell each unit for $750,000. Why wouldn't you? The so-called universal design justification seems like a total smokescreen to me. These additions don't create affordable, accessible housing at all, when accessible and affordable housing is what the city needs. They create more expensive housing marketed to investors and renters who can pay top dollar for it. The impact on neighbors is immediate and permanent. Loss of light, loss of air, green space, and the gradual erasure of just the rhythm of everyday life living in a row house community. We chat over our fences. We sit outside and grill. I wave to the guy down the block who just moved in. I wave up to the guy who's been here for 80 years. But that happens every day. For lots like mine, a 16-foot pushback with a 3rd story pop-up means that there'll be a 40-foot wall of construction block built directly on my property line. Not to mention a rooftop deck, staircases, back decks, all that aren't even counted in the pushback. So additional to the 16 feet, you have 10 to 16 more feet of just building, essentially. I urge the commission to reject this proposal. It ignores the very purpose of zoning, to provide adequate light and air to district residents and protect our quality of life. And thank you for your time.
Okay, thank you both. Let's see if we have any questions or comments. Commissioner Wright?
Thank you. Sorry to have jumped in earlier. Well, I want to say one thing, which is I actually support, and it comes from my own personal experience. I spent 10 years of my life here in the District of Columbia in a row house that had been converted into 4 condominiums, and we owned one of those condominiums, and it was a great way for me to get into the real estate market in the District of Columbia. That was the first piece of property that we bought, build equity so we could then move into a single family house. So I am not opposed to people coming in and converting some buildings that may have historically been single family into 2 or 3 condominiums. But I certainly agree with the speaker's concern when that conversion involves building something that, creates a very long wall along the property line and creates an addition that is out of scale with the original building. So I do have a problem with that. I think that I don't really, honestly, I don't have huge questions for either of the speakers, but I did want to acknowledge that it's not necessarily a bad thing to have a single family home broken into a couple of different condominium units, because it does create an opportunity for people to get their foot in the door in a very tough real estate market. But I am concerned about when that's done doing extremely large additions to that building to make that happen. I think that was really, it's not a question, it's just my only comment.
All right, thank you. Vice Chair Miller.
Thank you, Mr. Chairman, and thank you, Alan Gambrell. Good to see you, and Anthony Smith for your testimony here today and the information you provided, Mr. Gambrell, and with your co-author in Exhibit 11. And I think each of you have provided a visualization of some of the adverse impacts that could happen with this proposed change. And so anyway, I appreciate your being here. And if you, I don't know, Mr. Chairman, if did Mr. Smith want to write something and submit it for the record, or you? I mean, we have we'll get your transcript once we get that. But I don't know if you wanted to do that. But if you did, I would ask the chairman to allow that within a reasonable amount of time. So thank you, Mr. Chairman. I'm finished.
Okay, Mr. Smith, did you want that homework assignment, or it's fine with your testimony?
Thank you very much for that homework assignment. I'll take you up on that and submit something. All
right. For everybody testified, if you didn't have anything written, Michelle, when we close out, will give us some dates. But let me just say this. With full disclosure and making sure we understand, I know I was one of the commissioners. We were pushing, at least I was one of the ones who wanted the Office of Planning to look at this. Look at that 10-foot rule. I think I'm pretty sure I was. But I will say, from what I've heard today, now that really has me with pause. So I don't want to just push it on and say the Office of Planning presented this. I will tell you that some of the commissioners pushed for this. We asked for this because I thought I was thinking something totally opposite from what I'm hearing here in this hearing. And I will tell you that I need to go back and rethink even my comments then. So I appreciate all of you all, everyone who's testified today, because you brought me another perspective, and that's what hearings are all about, a different perspective. So we'll see where we go from here. And I appreciate everything that you all have given us. I don't have any questions. You all, everyone who's testified has enlightened my perspective of what I was trying. I was trying to achieve one thing, and it seems like we may have muddied the waters. At least I may have, because I know I pushed for it. So thank you all, and I'll just leave it at that. We'll see where we go from there. Thank you for your testimony. All right, Michelle, do we have anybody else? Nobody. Okay. All right. So do we need any dates, anything, stuff that we asked for? Like I think some submissions from Mr. Smith and others.
Unless, was the Office of Planning going to do any type of closing or anything? Were you going to have them do any closing or?
They don't usually do it in this.
Yeah, they don't always, but.
Yeah,
I didn't know if they were going to respond to, if you were going to have them respond to anything that was heard or not. But sure, I can give some dates.
Yeah, let's get some dates. But let me ask this. Does anybody need to hear anything from Ms. Steingasser anymore? I think Ms. Steingasser and him have done their due diligence of what was asked for.
Okay, sure.
I just don't know where I am now, so I don't know about others. Anybody need to? Let me just say, anybody need to hear anything from Ms. Steingasser?
Not today, but I am intrigued by the idea because again, building forms are like a balloon. If you push on one side, it has to pop out on the other side, and to get the right amount of space. I have to say I'm not particularly inclined towards this text amendment at this time. The only thing that I, again, think might be interesting would be to say, if one were to allow some additional depth of an addition, I think 16 is too much. Maybe 12 or 14, but in exchange, they would have to provide a light well, so that you're carving sort of part of the back of the building to make sure that there is some separation between at least one of the adjacent neighbors as you're, and in exchange for that, you might extend a little farther out than what we have now is the 10 feet. So maybe or maybe it's even an alternative, which says, you know, we keep the 10-foot rule, but if you're willing to provide a light well that creates more separation, then you can go out to 14 feet. Or, you know, I'm just throwing that out there. I think it is worth having Office of Planning maybe think about that and see if there is some something in that might be beneficial. So I'll just put that out there.
Okay. Rob, you have anything you want to add? Or you
Thank you, Mr. Chairman. I don't want to complicate things because I think it's kind of straightforward what's before us, but and where we are. But if the Office Plan is going to take the opportunity to entertain what Commissioner Wright is suggesting, which I think is something worth considering. I just would throw onto the table if another thing that could be matter of right. She's saying the 16 feet could be matter of right if you're going to provide some kind of required light well. The 16 feet could be matter of right if you're, in my view, if you're going to provide an affordable unit that meets the universal design standards, since that was part of the justification for proposing this. But I don't really want to complicate it or give the Office of Planning work assignments for their very heavy workload. So that's just a comment then. I'm not asking for anything. Thank you.
So I have, again, the Office Plan has done what we've asked them to do. I'm looking forward to having some deliberations and conversations. I'm ready to work with what we have, especially after what I've heard. But Ms. Shelton, if you can still give us some dates, it looks like we may have a conversation. And I know Commissioner Wright mentioned about the light well. I'm not sure if I'm there yet, but let's just see. Let's come up with some dates first.
Okay. Ms. Steingasser, how much time do you think you guys might need to come back? 2 weeks, 4 weeks?
I'm not quite sure what's being asked for. I mean, that's part of it. I mean, it's gotten, I'll be honest, it's gotten so complex. I'm not quite sure what we're being asked to do. Look at a light well, which is.
Well, I mean, that was just an idea. I mean, the other possibility is we just come back, you know, in the shortest possible time and either vote up or vote down the current proposal. And if it doesn't move forward, then, you know, maybe new ideas could be considered. But, you know, I honestly, I don't know if you, again, what our normal course of action is on things like this. Do we just sort of take the proposal that's before us and vote it up or down? Is that the best thing to do?
I think in this case, I mean, I'd like to talk it over with my colleagues at OP. But my read is that no one's comfortable moving forward with this. And,
I think
maybe OP should just withdraw the case for the time being and wait for another, bring it back later in another form. Time to be, you know.
But let me say this, Ms. Steingasser, you all did exactly what was asked for.
Yes.
You asked.
Yeah,
I did exactly what was asked for.
I appreciate your contribution to that. Yes.
But maybe
it doesn't seem like there is an overwhelming sense of what we're solving for. So that makes me a little bit worried that maybe the solution will be worse than what we're trying to solve for at this time. And so maybe the right thing to do is for OP to withdraw the case for the time being.
So you know what, I really want us to have a dialogue, because my intention was, if we had it there, we needed to deal with it, and I don't want to cut out the input. And so maybe I asked, maybe me personally, I don't know what others did, but maybe I asked for the wrong thing, because I didn't. I'm not getting to where I thought I was going to get.
Okay.
So that's just me, and I know I was asking for this. I don't know. I just would like to have a conversation among us, deliberate in public, because Commissioner Wright mentioned the light well, and I'm not saying that's the thing to do, but we need to toss that. I think we need to publicly toss that around. But I will say this though, Ms. Nagas, I do have pause now after what I've heard today.
Okay. Well, why don't we withdraw it and it can just be something that comes forward at a future date. I mean, my concern is about trying to require a light well, the complexity in permitting that and trying to get that written into regulations so that the guys in DOB can, it's going to get so complex for such a small.
Okay.
Well, and it needs
solutions.
additional analysis, and, it isn't something that's been taken to the community, or considered by them in any of your outreach efforts. And so I understand that throwing that idea out at this moment is difficult because it hasn't been vetted, by the staff or by the community. So I absolutely understand that that's a problem. I mean, maybe the best thing is to, maybe withdraw the current proposal, but ask planning not to give up and not to say, we're just never going to touch this issue again, but, put it back in the line of projects that needs to be done and take a look at some of these alternative options and come back at a future time.
So,
Yeah, I would prefer to do that.
okay, let's do this. After what we heard today, and again, I want to make it perfectly clear. I know I said it 300 times, and I'm gonna say it again. Obviously, the plan did what we asked them to do. So let's if my colleagues agree, I don't know, Rob, I think Commissioner Wright.
I'm fine with the direction that we're going.
Okay, Ms. Stein, I said thank you all for all the hard work. I can tell you this, I won't be asking for it no more because the result that I got today.
And I won't be here to respond. So
Well, I'll be able to get in touch with you and ask for it. No, I'm just playing.
Yeah. No,
so
we'll put something into the record tomorrow that just withdraws the case, and thank everybody for their participation. I mean, we had some really good conversations with the ANC about the issues. So
yeah,
that was good.
Appreciate all, even AIA, I know they were supportive, but I appreciate all the comments that we've heard. So we don't need to do a motion. You all are just going to withdraw.
We'll just put something in the record tomorrow.
Okay, well, we don't want to do anything else. We've done enough, colleagues. So I think that we'll just leave it where it is and let them withdraw the case, and then we'll leave it at that. So thank you again, Ms. Stein. So we'll see you all on the 30th. Ms. Shellen, do we need to do anything else?
Nothing, since you guys are going to allow them to voluntarily withdraw the case. Nothing else needs to be done since an order has been.
And I'll be the first to admit I think we've done enough, so I'll just leave that one there in the parking lot. All right, so with that, the commission will meet again on Thursday the 30th. I'm not sure let me see. We'll meet on these same platforms, and it is Zoning Commission case number 25-12, and we'll meet on these same platforms. I want to thank everyone, especially the public, for their participation and helping us get to where we are. You all have a great evening. This is adjourned.
Just a reminder, that is the first night case, 25-12.
And it's divided up, so it's not all that in one night. Okay. All right. Thanks, everybody. This hearing's adjourned.
Good evening.